video continues the discussion on some areas of argumentation. In the previous video, we discussed the some of the arguments that lawyers make about procedure. In this video, we continue with matters of interpretation, facts, and aside from facts, we go lastly to substantive responsibility. Um, Now let's go the matter with sufficient specificity in advance. So you have to resort to the plain meaning of the law. Um, Plain meaning has limitations. For example, firstly is because it's so attached to dictionaries and um, you derive meanings from dictionaries. Dictionaries, however, contain alternative meanings, and beyond that, the law or even contracts often are made in the midst of tough negotiations and result of struggles and compromises. So words do not often conform to the highest standards of draftsmanship. Therefore, it may be tough to have a coherent, plain meaning, so called plain meaning from words alone. All right. Um, Related to plain meaning is the concept of originalism. And related to plain meaning is the concept of originalism and evolution, actually. There are three approaches to original intent. First is the substantive original intent approach. You ask what authors had specifically had in mind, what they had in mind, rather. Second, the objective original intent. You ask what words the authors used generally meant at the time when the authors used them. Okay. And the third is about objective original intent with intended evolutionary change. Here, you ask what words that authors used generally meant at the time the authors used them, but you also assume that the authors intended for the words to develop new meanings as the world changed over time and language in common contemporaneous use adopted. So it's not really and principles. One of the most attractive, I would say, method is of interpretation deals with context. But I would like to note that there are different types of context available to reference. And much will really depend on the scope of the context, the orientation of the context that is being considered. For example, if you want to interpret a statute or a law, you have to consider the particular meanings uh, that are used or meant to be used. So most will argue that context should also include the document subject to the interpretation. Others would say you also should include other related laws, not just the law that you're interpreting, or other related contracts. Um, so you also consider the purpose. Um,
Others argue that purpose is really about, interpreting should really be in light of and consistent with the purpose of the law or the statute. Um, the question now that comes to mind is, how do we know the purpose? Usually, the starting point is the preamble, the whereas clauses. Some look at other related documents and even records. Okay, so if the position is not even supported by the principles found in a document, you could argue that principles based interpretation is not proper. You also look at parole evidence. Parole evidence holds that if two parties make a contract, that is the final and complete statement of their relationship, and no other document or reference, oral or written reference, should be looked at. Identify the so-called wiggle rooms. Uh, the wiggle rooms in contracts, in the law, or even treaties. And what you do is you try to eliminate uh, the ambiguity by resorting to essentially careful, imaginative, and um, logical ways of approaching a problem of interpretation. So at this juncture, I just want to say that interpretation is different from construction, although it's really um, treated in many ways as the same. But you know, it is possible to argue that a contract or the law should be completed by construction or adding terms that the parties would have inserted in the rule or in the law if they had thought of them or if they had not been negligent. So construction simply goes beyond interpretation. There's really the relationship between interpretation and morality. As a tool of argument, one's position on the separation of law from morality would depend sometimes on the outcome. So the way you approach your interpretative methods should also take into account as appropriate morality. You have this concept of um, that the parties intended or the drafters intended that rules or contracts meant to accomplish something by the words used. So it rejects an interpretation that would make a word or a provision ineffective. This is the UFED utile rule. Okay, it's a presumption of consistent usage and meaningful variation. Of course, you also have that precept that interpretation should avoid absurdity. Two types of absurdity. One is the text itself seems to be absurd in the sense that the word is or clause is patently wrong, or it's operating at cross purposes. And then the second is where the result just seems to be strange. So try to avoid interpretations that lead to absurdity. Okay, just to add into the mix, you have principles of lex specialis, where specific trumps the general, and you also use expresso unius, which is a canon of interpretation. Uh, these clear statement rules, interpretation against a draftsman, or the rule of lenity. So these things are almost the same, not the same, but these things are they go together. Um, it just tells us that the burden of clear speaking is on the rule maker or the person who drafts the contract. So if there's ambiguity, it will be taken against them. Lenity is a principle that's pro accused. So, because the legislature drafted the legislation or law, um, the ambiguity is construed against the legislature and in favor of the accused. So, last one is the concept of reductio ad absurdum. So, it is the extension of a proposed principle to absurd or undesirable lengths. So we don't want to extend principles that will make them undesirable, but really to undesirable results. So that's about interpretation. We will just go to facts. Um, Facts are important and salient. Uh, we don't know which rules apply until we know the facts. Um, and also, largely we don't know which facts that are important until we determine the rules. It's cyclical, but um, facts are important as uh, mentioned, because you know the rules. Once you get the handle of the facts, you will know the rules. Okay, but there are things where in evidence and there are missing links, and it's the job of the lawyer to carefully examine the factual components of the opponent's claim and, somehow try to cast doubt on the facts within ethical parameters. Always be in the lookout as well for causation of harm and negligence. One of the areas in which law is different from ordinary experience is the analysis of causation. Uh, in fact, a lot of the precepts or legal rules that we know are there to determine harm and negligence. So you get those things from the facts. Statistical evidence and scientific evidence, uh, which can be a good source of circumstantial evidence, if not direct evidence, and can be persuasive. But I also want to warn that there are certain arguments that lawyers use rather, to question the quality of evidence, such as the best evidence rule, which tells us that in general, use the primary evidence rather, and evidence can be excluded because they are unreliable or easy to fabricate. And estoppel can be there. Substantive responsibility. The substantive responsibility is all over the law, especially in certain areas of the law. So when the lawyer argues about substantive responsibility, um, there are certain things that you have to consider and put into perspective. For example, there are concepts about the reasonable person and due diligence. So this one requires you to engage in a risk assessment of actions or omissions. Full risk assessment would be uh, adjusted or even calculated based on analysis. And lawyers use exceptional circumstances, such as force majeure, to elude responsibility. And lastly, there is this debate all the time when you deal with substantive responsibility of form over substance,